research on this, and the answer is the Uniform Commercial Code. There is nothing else. I mean, I looked through Title 12. I didn't see anything. So I don't see how the UCC couldn't be federal law, but you're going to start seeing me go more into state courts now with a lot of the litigation because I don't know how to navigate it, and I don't think the federal courts even know how to navigate it. So you're seeing the federal courts dismiss my cases as vapor money theory. I think vapor money theory just means we don't have jurisdiction over this because the UCC is not federal law, but we don't want to say that. I don't know what else it could be. So I'm just going to start going into state court where the UCC is law for sure. So for example, in California, it's the California Commercial Code. Okay? Just a little point on that. I'm still going to try to get it worked out in the federal courts, but I think it will be easier in the state courts because the commercial code variations of the UCC are law at the state level. Okay? So if you guys are getting your litigation prepared, which you should always be doing, come back to me for a moment. You should always be building your case. You should always assume they're never going to perform. And you should just be, the chances of you suing is 99.99999999999999999999999999999. Okay? It might as well be 100%. So you should be operating the entire time, and you should be preparing everything the entire time for 100% litigation. Everything you do before, it's like foreplay. Everything you do before litigation is just foreplay. It's almost kind of irrelevant. And you should assume everything you send them, they're going to ignore. I think if you do it that way, you're going to feel better, you're going to have less anxiety, and you're going to be more in control of the situation as you move through these various things and these various processes. To assume you're going to get anything done through the mail is just a complete, I think it's lunacy. And I know everyone's trying to do that. Everybody's trying to do that. Everyone's trying to sell courses and do all this stuff, trying to promise that. I don't think that's ever going to happen. And yeah, I know I did that show with George forever ago, and I don't know whatever happened with that. I get asked that all the time, and I just don't give a shit. Even if they did accept a bill of exchange or a draft, and you send it back, and you endorse it and send it back, who's to say they won't the next month? You see my point? So yeah, you can get little wins here and there, little tiny hits, and I can make a video out of it just like I did, but it's not realistic. And if I was a fucking big guru and I wanted to be your big guru, I would take those little wins that are super hit and miss, and I'd blow those up to make it seem like, that's everything. And some people might say, oh, that's what you're doing with cars. I mean, not really. The car thing's super easy. I mean, we got a lot of people who go in and they're kicked out of dealerships, and not everyone's winning on that. But I think after this video, I think almost everyone's going to be winning with the cars. It's going to be we're going to work this down to such a science that everybody's going to get a free car. It's just the easiest thing in the world, right? And they're going to get paid for getting the free car. That's the most important part. It's not just about getting a free car. It's really not. That's not what we're doing. People say, oh, they're getting free cars. That's not what we're doing. I know I say that sometimes just for effect. What we're doing is we're getting paid to take free cars. You guys have to understand. Big difference. Big difference. We are not getting free cars. We are getting paid to take free cars. Big difference. Big difference. Okay? So we have these two different types of negotiable instruments. We have the unconditional promise to pay, and we have the unconditional order to pay, which you guys should all be familiar with that so far. That's the basis of everything, really, right? So what I've done on this is I've created these two lines, and we go to the two different types of negotiable instruments, right? And then I give a bunch of different examples of each one. So for example, an unconditional promise to pay when you sign a traffic ticket. If you sign it, it's a note. If I know in a lot of states people are like, oh, they don't make us sign it. No problem. So again, this new development that I've developed is going to put you into even a greater position of power, because for all the people that are in states where they don't let you sign the note, that's okay. That's actually totally fine, because if it's a traffic ticket and you didn't sign it, it's actually a draft. They're ordering you to pay. When you sign it, you're promising to perform, because payment and performance mean the same thing. I'm probably going to add that definition to the sidebar, the definition of payment. You guys should know that. I've only repeated it 10 billion times. But when you promise to show up in court at a certain time, which is what you're doing when you sign a traffic ticket, it's more of a note, I guess, in my opinion. I think it's factual, but you could say in my opinion. Whereas if they just throw it in your window, which I've heard those kind of stories too, and you don't sign it, that would be more of an unconditional order to pay, a draft. Okay. And important side note here in the middle in bold, if an instrument falls within the definition of both note and draft, a person entitled to enforce the instrument may treat it as either, right? And I have the definition of person entitled to enforce right here. It means the holder or a non-holder in possession of the instrument who has the rights of a holder, or a person who isn't in possession of the instrument that should have the rights of a holder. It's kind of complicated, but it's basically the person who has the rights to be the holder, whether they actually physically have it or not. Okay, there's more to it. Obviously, you can look up more. I'm trying to simplify this, and then if you want to go ultra deep dive, which you should on all the words, this flowchart will help you do that quite a bit. Okay, so you could say, if you wanted to change this just a tiny bit, make it seem a little bit more understandable, if the instrument falls within the definition of both note and draft, a holder may treat it as either. Okay? So, so examples of an unconditional order to pay, right? It's pretty simple. Parking ticket, tax bill, utility bill, credit card bill, court order or judgment, a check. A check is a special definition. I'm not going to pull it up right now. It's something like a draft, which is drawable from a banking institution. So a check is both a draft and a check, whereas a draft is just a draft. So if you look at a check, like out of a checkbook, and it says pay to the order of, it's still an unconditional order to pay. And then as far as I can tell, when you add the routing and account numbers to it, now it's drawable on a bank, and now it becomes a draft and a check. But if you took a check and you remove the routing and account numbers off of it, it still would be a draft. So the check thing is a little bit interesting for people who have not gone down that rabbit hole too much. A check is both, and a draft is just doesn't have routing and account numbers, and it's not drawable off of a banking institution. A check is you have the draft, and then you add banking institution information onto the draft, which would be the routing and account number. Okay. So there's been a lot of people. I've even seen people like people send me like, oh, this guy went to jail and this guy went to jail. Well, because what happened was they took a draft, they turned it into a check, and then they went down this whole hot check avenue, blah, 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 blah. The fact that it has routing and account number on the draft is irrelevant, because you can remove the routing and account number and it's still a draft. So it's still a negotiable instrument regardless of whether it has or doesn't, or you could even you could take a check and literally physically tear the routing and account number section off of the check. It would no longer be a check. Now it's just a draft. Whereas before it was a draft and a check. Once you physically tear that section off, now it's just a draft. And you have to kind of go down that rabbit hole to figure all that out for yourself. Okay. Now this one's a bit interesting. I'm like 99% sure on this one. A debit card transaction. A debit card transaction is an unconditional order to pay. You are unconditionally ordering the bank to pay someone else. It all happens so fast that there's it seems, because it's so instant and digitized, but the actual debit transaction itself would technically be a draft, which I think is kind of fascinating, right? Medical bills, right? And then on the note side, we have other things such as loan promissory notes, all credit card transactions. So credit card transactions would be promises. Debit card transactions would be orders. And actually, debit card transactions would also be checks or e-checks because they're drawable on a banking institution. So they're drafts and checks, debit card transactions. Whereas a credit card transaction would be a note. Okay? Very similar way that these things operate, but they are different, right? Federal Reserve notes, obviously, all currencies, as far as I can tell from the research I've done, all currencies that have a central bank are all unconditional promises to pay, which I think is pretty fascinating. I know a lot of you guys have asked me, and I ignore all the emails and messages because I get dozens of them a day. Does this work in whatever country? And this is the answer to that question. I've never really answered that question. I didn't really know. And I'm not 100% positive on this, but I am like 98% positive on this. All currencies that have a central bank are, they're not money. They're actually currency. They're actually negotiable instruments. It's the same system we have in America, just duplicated. Okay? Insurance policies is a really fascinating one. When you promise to pay the original policy, they can actually take that promise to pay and take it to the window or sell it or exchange it as a bearer instrument payable to the bearer. And then they can actually fund the entire policy using the original note. And then they become the trustees and you become the beneficiary of that policy. That's how I think insurance actually works in its most basic functionality. You fund your own insurance policies and then you become the beneficiary of that insurance policy. So basically it's bullshit, just like everything else. Okay. This, I don't need this. Okay. So here's where we're going to get into where there's a bit of a change, right? So the maker or issuer, right? So if we go here to the word maker, right? I don't know what this thing is. We're going to have to move this or something. Let's see here. Means a person who signs or is identified in a note as a person undertaking to pay, right? So it's a bit complicated because you're the endorser on behalf of the ens legis. The ens legis is the one who is the person undertaking to pay. But it says here a person who signs or is identified in a note as a person undertaking to pay. So it's a little bit complex. Like, I wanted to kind of bring this up because it's like you could fight this, for all the people who have been doing the qualified and special endorsement on the original note. You could say that it's or as identified in a note I just don't think it's going to work the way that I originally thought. I've been doing a lot of thinking about this. I have had a few people bring this up to me. By the way, the reason why I kind of freak out on people who brought this up in the past, for people who kind of notice that, is because I don't like it when people just say, oh, you can't do that. Oh, you can't do that. It's like, motherfucker, we're trying to figure this shit out. Like, if you're going to say, oh, you can't do that, then tell us what we could do or other options or other avenues we can look at or something. Don't just close the doors on us. We're trying to open the doors and go through the doors. So if you come around just closing the doors all the time, guess who's going to close the door on you? I am. So if you get a little confused and you feel like you're trying to help and, it's okay. The reason why I didn't listen to you guys and the reason why I freaked out on a lot of people or just a couple people about this whole maker issuer thing is because I didn't, it's just like, you're just trying to close the door on me, bro. And like, I'm going to freak out and block you. Like, that's kind of how I feel, right? So if you're going to give tips and tricks and you're going to move this forward and you're going to help us understand this stuff, if you're going to say you can't do A, please add an additional option such as a B or a C or other areas we can look at the information. And then I'm going to be much more likely to bring your information into consideration, right? So I've been told for a while now, a handful of months, about this whole maker issuer thing, and I just kind of ignored it, right? But now I'm starting to see that we need to adjust a bit, okay? So issue means the first delivery of an instrument by the maker or drawer. So maker, we've already gone over what that means. Drawer is right here on the left-hand side, means a person who signs or is identified in a draft as the person ordering payment. So it's the person who's ordering, the person doing the ordering, okay? And by the way, signature, I'm going to add that as well. I'm going to add, let me just make a note here. I'm going to add a couple of definitions to this. I'm going to add signature, add signature, add payment. Those are two really important words that we don't have on here, okay? People get very mixed up by the word signature, right? I don't think I have it on here. The word signature means like any symbol or logo or anything that indicates that that, you know, it's being accepted or been approved or been agreed with. So when you get a bill from your utility company and it has the utility company's logo on it, that logo itself is a signature. If it has just, you know, City of Glendale in all caps, municipal bill, just the fact that it has City of Glendale in all caps, that is a signature as per the definition of signature. So you guys have to get off this whole like, oh, but it's not signed. You don't understand the definition of the word signature. The word signature is any symbol or any logo or anything that indicates or shows that it's been approved or accepted or you're in agreement with it. So the fact that their logo's on it and the fact that they sent it to you, what are they going to do? Oh, we didn't mean it. What's of course you did. The fuck are you talking about? You didn't mean to do it. Like, of course you did, right? So it is signed. Okay. So any confusion on that, you guys can, but that is that's signed by the drawer, the person ordering payment. So that logo would be the signature of the drawer. Okay. So issue means the first delivery of an instrument by the maker or drawer. So maker is you the first time you sign the note and bring it into existence, right? And the drawer is the person who's ordering. That would come a little later. The drawer comes a little later when you have the draft, okay? Whether to the holder or non-holder for the purpose of giving rights to the instrument to any person. So when you first sign a promissory note, which would be a credit card transaction, or a loan, or these cars everybody's getting, right? You're the maker or the issuer, and if you look at under endorsement, means the signature other than that of a maker, drawer, or acceptor. So this is kind of the issue that I've been trying to figure out how to fix, and this is the flow chart that I created to fix that problem. And like I said, it went from a one-step to a two-step process, but I think overall it's going to be quite a bit easier for people to actually get through this, okay? So instead of signing the original note as the maker or issuing the note with a qualified and special endorsement, which now I realize we can't actually do that, right? What you can do is you can sign as the representative of a represented person as per UCC 3-402 subsection B1. And the way that would look is, and I don't know how to remove these stupid symbols. Let me see if I can figure this out. Maybe that's what we needed. Hey, look at that. The tech wizard over here. Okay. So for example, by Williams, Brandon Joe, representative for colon, these both have colons on them, colon, all caps, Brandon Joe Williams, represented person. If you look in 3-402 subsection B1, they specifically use the word representative and specifically use the term represented person. So I don't necessarily recommend that you change the terminology on that one. I know you guys are always asking me, how do I sign things and how do I sign things? When it comes to endorsements, that's up to you. I can't tell you how to endorse everything. You need to actually understand endorsements. I think this is a little bit more static, meaning as far as I'm concerned, you would just literally always, as the maker or issuer, this is always how you'd sign. I mean, I don't really see any other versions or any other ways that you would sign that would be beneficial for you. Now, that could change in the future. I may realize something else and we can change this up in the future. But I also think you got to also keep in mind that by signing this way, because we have a lot of people going in and signing with the qualified and the special endorsement, and then the finance people in the dealership are going fucking ape shit, right? I think this type of signature has a much, 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 much lower chance that it's going to cause people to like totally lose their shit, right? And actually, in fact, if they completely went ballistic on this signature, you could just do by Williams, Brandon Joe, agent, and no other information at all whatsoever. This one here is a little bit more clear, and this one here is better for 3-402B1. But if you were absolutely pressed, and you just like really wanted to walk out of there with a car and whatever, I think by Williams, Brandon Joe, agent, it wouldn't even be the end of the world. And sometimes, just as a personal thing, a personal tip that I usually do for myself, if I think even agent would cause people to freak out, I'll sign my name in a really, really sloppy, convoluted way, and then I'll do agent, and it's so convoluted and sloppy that you can just barely read what it says. But if I ever moved into like a litigation situation, I would be able to point it out and say, yeah, it says agent. And if you looked at it for more than a second, you would see, oh yeah, it says agent. So that's another tip that I can say for you guys. If you are really, really scared about going into a dealership, if you're really, really scared about doing this stuff, the absolute lowest level in terms of risk that you're going to have in terms of being the maker or issuing a note is going to be by Williams, Brandon Joe, agent, all just fucking doctor signature. Like the kind of like dog shit kind of a signature that you would see like a doctor do. As long as a jury or a judge can look at it and say that, yeah, it says what he says it says. You know, it can't be so sloppy to where you can't even read it at all. Because then if you're in litigation and you say, oh yeah, it says agent, and they're like, what the fuck? No, it doesn't. It's just a blob. So it's got to be somewhere in the middle. Okay. Now the reason why I originally told you guys that I think this two-step process is going to make it easier is people are nervous about going in and having to explain and getting attacked by the fucking, and I've heard a lot of stories of people getting, the finance people going absolutely fucking ballistic. Okay. This is going to avoid all of that, and it's going to make acquiring the vehicle very easy. So overall, even though we're going from a one-step process to a two-step process, the overall difficulty of this is going down by quite a lot, in my opinion, because of that. Okay. So now that you've been the maker or issued the note, which means the first time it's being brought into existence, and you've tendered that back to the person entitled to enforce the instrument, which is the people you're going to hand it to after you sign it. Now, the very first thing you're going to do is you're going to call up the finance company and you're going to request a payoff sheet or some kind of unconditional order to pay. I would go so far as to say even farther than this. You want an unconditional order to pay for the full amount. So you want to, like with cars and stuff, I just asked for a payoff sheet, and they sent me and it says this payoff sheet is good until blah date. So as per the rules of dishonor, UCC 3-502, you would need to perform on that draft prior to the end date of when that draft was good till. One of the rules of dishonor is that you performed after the date. So if you don't perform within the date of when the draft is good till, they actually can legally dishonor that draft, and it would not be payable. So this would not work if you did that. So if you do this, Get it in the mail well before the expiration date of the draft. Okay. Now, once you request the payoff sheet or some kind of unconditional order to pay for ideally the whole amount, now once you receive that draft in the mail, now you become the holder. See? Now, the reason why I have a second line here from note to holder is because let's say you got a hold of someone else's note and you weren't the maker or issuer of the note. If you got a hold of somebody else's note, for example, a great example of that is a Federal Reserve note. So when you acquire a Federal Reserve note, you are not the maker or issuer. So you're not going to go down this whole thing here. You just go bing, straight from here, boom, straight to being the holder. That's why there's two different avenues of direction here, right? So in a person's normal life, every time you get a Federal Reserve note, bing, you go straight from this box to this box. Anytime you do a credit card transaction, anytime you get a loan, anytime like that, you're going bing to this box, bing to this box, bing to this box, and then up, and then boom. Now you're in this box. After receiving a draft, though. See, you're going to get that draft, and then boom, now you're the holder. Okay. Now, in order to negotiate it, you can't be the maker, drawer, or acceptor. So that's why this is so important. You want to make sure it's like, no, this name in all capital letters is some sort of an estate or corporation or Title VIII organization or whatever. It's a different person, right? For example, this person is a U.S. citizen as per 28 U.S.C. 9102 subsection 18. This person is not a U.S. citizen as per 28 U.S.C. 9102 subsection 18. This person is a resident of state of California per naturalization, which is 8 U.S.C. 1101 subsection A23. This person is not a resident of state of California. You don't need to put all that in your litigation stuff if you don't want to. It just gives them more areas to be pieces of shit. But if there is any confusion later on, that's what I would put in the litigation. That's what I've been putting in the litigation. Everyone tends to ignore that and try as hard as they can to stay away from that. They don't want to have that conversation, but the truth is the truth. I can't change that. Okay. So, that's just the way it is. I'm not going to freak out. I mean, the truth is the truth. End of story. So if you don't like it, that's your problem, not mine. Now, I have an additional handling for this, which I developed, which I think is brilliant. Okay. So once you are the holder, right? Now you can sign as the representative or agent of the ens legis name, which is what you see everybody do. I thought about this for a while too. Like, if I'm the agent, then I represent them. Then I kind of am like operating as though I am them. How would that work, right? But keep in mind all the notes that we've already found, right? All of the endorsements that we've already found, they all say agent on them, right? Or senior vice president or warehouse, blah, 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 blah. So if we go through all these endorsements that we've seen banks using, it proves the point that an agent can endorse an instrument. And I'll show you that right now. Okay, so we have here, this one here is the capture manager. Capture manager means employee. Employee means agent. It's the same thing as saying agent. Okay. If we say managing director, it's an employee. That's an agent. They represent the company. Here we have executive vice president. That's an agent. Capture manager. That's an agent. So I had that same confusion. That confusion is a physical impossibility. Assistant secretary. This one here has been crossed out, so I can't tell. Assistant VP of operations. That's an agent, right? They're all agents or employees. So I know some people are like, well, hold on. If I'm the agent, then I represent them. How can I, as far as everybody else doing it, you can do that. Now let's just say, if I'm being devil's advocate, let's just say, You do that, and in litigation, they're like, no. All caps Brandon Joe Williams, and Brandon Joe Williams is the same person. Okay. Now, we can go down that road and we can turn that into 9 months of fighting, or I've come up with a secondary option that's very fascinating, right? So the rules of negotiation is it can be negotiated by anybody who's not the maker, drawer, or acceptor, right? And because it doesn't state the payee on it, it's payable to bearer. So all you do is you just take, let's say this is the fucking bill in my hand right here. I just take it and I physically hand it to my daughter or my wife or my friend, and now they are the holder because an instrument that's payable to bearer can be negotiated by transfer alone, right? You literally hand it to a friend or family member, right? And then they endorse the instrument. So you also have that as well, where, you can just hand it to somebody else and they can endorse the instrument. So what I would do in a situation like that is I would do it like this, all caps, and then upper and lowercase. And then if the court totally freaked out, I would say, hey, and I would talk more like in settlement agreement. Okay, cool. So now we're actually on the subject. So let's do this. If I had my wife endorse the instrument, then would you guys accept it? Because that would actually follow the rules of what you're asking here. Can we do it that way? And then you can run it from like a settlement agreement kind of viewpoint, rather than going in for combat for 5 months on does the Due Diligence exist. We can just not do that at all, and we can just settle. Okay, fine. I won't do that anymore. I won't endorse the instrument. My wife will. What do you guys think about that? Right. That's kind of a little thing I was developing when I was building out this flowchart, which might be something really interesting for you guys. I wouldn't do that up front. I would just stick with ens legis and you as the representative, because that's actually what the truth is. But in litigation, just have somebody else, a friend or a family member or your accountant or whoever, just have them fucking endorse it. I mean, that seems like a very simple way of settling the dispute in a court. So super easy, definitely more power for you as an individual in the situation, I think, overall, right? Here's a little box with my own little typed up definitions for the different types of endorsements, because they're very complicated. They are not full definitions. They're like ultra simplified. So for those of you that are not familiar with these various kinds of endorsements, you should look up more information about them. There are additional types of endorsements above and beyond these three. The additional types of endorsements above and beyond these three, you just don't really see them. But I think if you really want to take your knowledge of this information to the maximal level, you should study conditional endorsements. You should study, I can't even pronounce it, amalgamalious endorsements. They're not top priority, and they're not even something you're probably going to be using. So I didn't list them here. Okay. So here's an example. This is not anything new. This is finally, we're getting back to what you guys have been knowing. An example of a qualified and special endorsement, which is clarified that I'm not the maker, drawer, or acceptor, right? /S/ like this. That means like a legal signature on a digital document. So this is like the same thing as me doing a handwritten signature when I do /S/. And you can look that up. What does /S/ mean? And it'll explain that to you. Okay. Now, once you endorse the instrument, the draft, you're going to tender that draft back to the person entitled to enforce the instrument. Now, this is where things get interesting. As per 3-311, and you guys have me, I'm always talking about 3-603B. You guys see me talking about that all the time, right? I talk about that every day, right? This is actually a more expansive section talking about the power that you have under 3-603B. It's 3-311, right? This talks all about, like, if you send in an instrument, they have to apply it as a payment. If they don't, you can sue. And they need to discharge, right? So like in litigation, the way it works is you have duty, breach, damages, right? So I would go so far as to say the duty that they had to apply this payment would actually be under 3-311. You can also list 3-603B, but that's almost like just secondary. I think 3-603B just comes from 3-311. That's that, and then here we have three arrows, right? This is conditional over here, and then this is the two choices they have. They only have two choices: applied as a payment, hooray, which is what we're trying to get done, or the instrument is dishonored in accordance with UCC 3-502. You should be very familiar with the ways in which an instrument can be dishonored. There's not very many of them, and almost all of them just involve dates. Like if it's due by a certain date, or if it's good until a certain date and you don't perform by that date, that's like 85% of all the rules of dishonor. So as long as you do things timely, this is kind of a foolproof system that I'm developing here. There's not really any way for you to fall down. You should be very familiar with 3-502 though. Very important. If they fail to do either one of these, that's where you're going to enforce 3-311 and 3-603B and force them to do one or the other. At that point, there's damages, though, as well. So even if they do dishonor the instrument legitimately, there would still be damages. So you're still going to get paid either way. So if they don't do either one, that you force them to do either one, plus you get paid. So even if they dishonor it, you're still going to get paid. If they apply it as a payment, you're going to get additional damages on top of the payment being applied. So you get paid either way. We're pretty cool, right? So this is the remedy section. This one I just added today, I think, actually. So if you look at UCC 3-104 subsection J, you guys have heard this before, CDs. These were popular like 25 years ago, certificates of deposit, right? So if you look at the actual definition of a certificate of deposit, it means an instrument containing an acknowledgement by a bank that a sum of money has been received by the bank and a promise by the bank to repay the sum of money. A certificate of deposit is a note of the bank. Now, this is extremely fascinating and brand new information for me to be releasing. So what this means is when you create an unconditional promise to pay by using a credit card and you get a receipt after the credit card transaction takes place, that receipt itself is the bank promising to pay you because you've deposited money. You've created an unconditional promise to pay and you've deposited in the bank. So if we break down the terms here, certificate means evidence that something occurred, and then deposit, a certificate of deposit is evidence that a deposit took place. A receipt is evidence that a deposit took place, and a receipt is actually a promissory note where you are actually the drawer, even though you're not. A little bit complicated. Are you ordering them? They're kind of ordering themselves in a way. But anyways, I'd say you're probably the drawer, and then they would actually be the drawee in that receipt. So when you hear people talking about sending all the receipts into the IRS and doing all this crazy-ass IRS shit, which I really don't want to get into, and I've kind of abandoned all of my research into those areas, I don't really want to get involved in any of that. I think it's a very slow process, and I'm trying to learn. And I think working with the IRS, you're never going to learn anything. They never give you any information about anything. You either know or you don't. There's no in between. There's no questions. There's no answers and nothing. When people send in all the receipts and they're trying to get like original issue discounts and all this kind of stuff, it's like, this right here, I think, is kind of like the missing puzzle piece for a lot of that. For all the people out there who are trying to get IRS type stuff to work, which, more power to you. If you do, let me know. But I get sent a whole lot of stuff all the time, and nothing is functional yet. So I don't really like to listen to it or hear it. But I'm not going to be Debbie Downer and say that it's never going to work and no one's ever going to figure it out. I think this is the reason why those receipts have value. I think those receipts are actually notes. They're notes of the bank promising to pay you in the future on the deposit that you've made, right? Very, very interesting, huge discovery, huge clarification, brought a lot of understanding to me personally. I have gone through waves of looking at all my receipts and trying to clear up every single transaction number and everything else on all of them. Haven't done that in a while. As soon as I realized this a couple days ago, I started doing that again for like the 5th time. So very, very interesting. Very, very, very interesting. That means that the receipts are technically currency. That means that the receipts, they're not money, but we can say they're money. They're negotiable instruments. So does that mean you can take your receipt and go and deposit in your bank account? Technically, yes. Good luck. But technically, yes, you can. Okay. Consideration. We've gone over that a lot in the course. Consideration is important. 3-303B is very, very clear that if you don't get consideration, then you have a cause of action. That's just normal. That's just normal contract law. Nothing special, but it is codified in the UCC under 3-303B. So you can use that in all of your litigation. You can use that as a cause of action or litigation or clarification or even arbitration. I wanted to talk about arbitration. I know I did that video with Monza. The reason why I'm still not going to do arbitration is because arbitration requires you to waive your rights. I'm never going to waive my rights, bro. Like for anything, for any reason, for anybody, for anything ever, probably for like the day I die. So anything, even if it is cool and even if people are getting some good stuff out of it, which I'm not going to bang on it too hard because it seems like Monza's got a lot of good things to say about it. Waiving my rights is just totally out of the question. So the bottom line is just that's kind of where I'm at right now. That might change in the future, but I'm not going to be. You start waiving your rights and you become the guy who waives his rights, and I'm not the guy who waives his rights. So I'm not going to be that guy. Okay. So next thing here, UCC 3-305A13, Roman numeral 3. Says fraud that induced the obligor to sign the instrument with neither knowledge nor reasonable opportunity to learn of its character or its essential terms. It's a fraud point, right? I think this is a really, really strong place for you to build a claim, to build a cause of action. I will definitely be building causes of action based off this. It's a very, very powerful. It can be used over the phone. You can use all of these over the phone. You can use all of these in letters. You can use them in litigation, causes of action. Very, very powerful. Very, very powerful section, right? And then here is just a repeat. 3-301 and 3-603B covers the intense obligation that the acceptor has to perform on an instrument when you send it to them, right? Very, very powerful. This is kind of like the basis of everything I do. It's the basis of all my litigation. I think I'm just getting a lot better at explaining that. I think that's kind of been the struggle. I've had a struggle trying to explain that. That's going to keep getting clearer and clearer as we continue to file in more cases and kind of move forward into additional things, right? This isn't really a remedy. It's more of like just a really important point. Words like you or your, for example, in the MX card member agreement, including also credit reporting agreements, you and your has a lot of different definitions, and it's like the craziest fraudulent words ever. You may refer to anyone who agrees to pay for the account, right? So you and your is a really crazy place to look for a lot of litigation questions, discovery questions for litigation, that kind of thing. And I think people should be more aware of the definitions of you and your. I think it's a really important place to make sure that whenever you see, like for example, Mr. Williams, are you going to be representing yourself, right? The word represent, the definition of the word represent means there has to be two parties. So my response to that would be, clarifying the fact that the first you in that sentence would mean me as a man, which would not be an individual or a person. And then the second word, yourself, in that sentence means the ens legis, which is a U.S. citizen and is a resident of state of California. And then I would say under those definitions, yes, the answer to that question would be yes. So you want to clarify you, your, yourself. Those kinds of words are just rife with confusion, and you can step on a landmine real bad with those words. You got to be careful with those words all the time. Okay. This is just an important note. This isn't really a remedy. It's just an important note, which is why the arrow looks a little different. UCC 1-20120 defines good faith as means honesty in fact and the observance of reasonable commercial standards of fair dealing. Okay. So it's just an important part of all the remedies that you're going to be doing, because you're going to be talking about, I think, all my litigation constantly. Bad faith and good faith is constantly coming up in all the litigation. So it's an important point to know. And you guys should be studying all my litigation, because I'm fucking everything up for you. So you don't have to, basically. So if you read all my cases, you're going to avoid tremendous amounts of mistakes and bullshit that, I mean, I'm having a blast, and I won't take it back for the world. But if you're looking to avoid months of bullshit, just study my cases, and you'll know what not to do. It's very simple. If you request the original note, there's a lot of rules as to what an original is, which is one of the points that Dr. Graves goes into in quite a bit of detail on the howtowinincourt.com jurisdictionary course, which is a cool course, by the way. You should check it out. He talks a lot about originals and how intense the definition of an original is. You should know that information, because if you request the original note, which they basically may really have a hard time producing for you, you actually become the holder of the note in accordance with 3-309A3, and you can actually negotiate the instrument, which is fucking crazy. So it's like, you say the magical incantation, and then poof, the note just appears in your fucking hand, basically, which I think is a cool remedy, right? So that's it. That's the flow chart that I have so far. I'm going to add in signature and payment. I may add some other things. I may adjust this in some ways. I do not believe that flow chart is going to be going through any massive changes, but I could be wrong. So there you go. We have been, like I said in the video, I do want to, I already said that. Let's just skip that. There's a little bit of confusion. We already covered the signature confusion. There's a little bit of confusion on, is it payable on demand or payable to bearer, right? People are confused on, is the draft payable to bearer, right? So if we go to UCC 3-309, actually, I think it's 3-109. Yeah. Right. If it doesn't state the payee, it's payable to bearer. So if you can't figure out who it's payable to, it's payable to bearer. It's very simple. So don't worry about that. I have gotten several reports of people who are talking to managers at the dealerships, and the managers are telling the people that the way their contract is structured with the financing company, if the person buying the car does not make at least one payment, then the dealership is responsible for the car, or like has to buy back the car. There's some goofy shit on that. So this new way that we're doing things is better, because when you request the unconditional order to pay, the draft, and you send back the endorsed instrument to make a payment, that is also going to protect the dealership as well. Okay? Drafts have not changed really at all, hardly. There's almost no change on the drafts. A lot of what you saw in the flow chart only changes the maker issue, and that only involves notes. That has nothing to do with drafts. So just the note side has changed. The draft side is still the same so far. Okay. Yeah, you need to go into all these things, building the case, ready to go on litigation. I don't recommend that you go into any of these situations, whether it be a mortgage or a loan or a car, and just think you can just get away with it. That's kind of stupid, because you got to think too. After you get the note and you issue the note, and then you get the unconditional order to pay, and then you endorse that and send it in. You're going to want to get all of the additional interest available on the account. So you should be suing. I don't see why you wouldn't sue the financing company either way. Even if they sent you a congratulations, we've processed your note. Thank you so much. Enjoy your car forever, and the title and chocolates. I'd still sue the financing company, because the thing is that you're entitled to the interest on the account as well. So I don't see why you wouldn't litigate. It's the best part of all of this. The car is actually not the best part at all, in my opinion. The litigation is the best part. That's the most fun. Maybe not at first, which I understand, but I assure you, you do it once or twice, you won't care about the car anymore. You're only going to care about the lawsuit. That's where all the fun's at, okay? Let's see. Yeah, this makes it a lot simpler up front to get the car. Less nerve-wracking, less complicated. I'm working on a credit reprogramming lawsuit that will completely change the entire credit repair space forever. It's going to just completely blow open all credit, everything. That's going to be a while before I had that done, maybe the end of the year. And then I have 5 mortgages that I'm working on. All this stuff is going to go all into that, so I'm having to rewrite things, and it's just a mess. But I have to implement all these things that we're learning, so things have to change. And I'm also working on 2 counties. 2 counties. So we're going after 2 counties. We're going after 5 mortgages, and then credit repair, credit reprogramming. Okay. So you'll see all that happening over the next few months. I haven't been doing very many shows. I have a bunch of shows booked for November. I'm going to start getting back on that train as well. So you'll start seeing me do shows again. Just been taking some time off, like I said, much needed. And now I'm kind of getting back into the driver's seat. Be sure to build your cases. Be sure to be reading all of the stuff in my cases. You're going to start seeing a lot more state cases, so please go onto the state website for California and be sure you can access all of my stuff through there. Sadly, the California stuff's a lot more expensive than the Pacer stuff, and also I don't have recap. So I may set up a system where one of you guys can share a lot of the stuff that happens in those state cases. I don't really know yet how we're going to do that. Maybe we'll do a Dropbox or something. But anyways, we'll figure that out as we go. And I think that's everything I wanted to share with you guys. This flowchart may change, so please check the website for any updates. I hope it was helpful, and I'll see you later. Bye-bye.